public prosecution is under statutory duty under Section 388 of the Criminal Procedure Code to institute an inquest proceedings before a competent court in terms of Section 387 thereof. I also consider that the court should give effect to the deceased's family interest, knowing how the deceased met this death for emotional relief and establish whether there was any criminal or tortious causes which may attract consequences in penal and pecuniary redress. Your Honor, nobody should stop the court to look at the law as it is, whether that law has been argued on this floor, or so long as that law we are mentioning is in statute. Whether lawyers don't argue it, whether lawyers don't present it in form of appeal, the court is duty bound to look at the law. Does it have jurisdiction to sit in this matter, or it needs to be declared an inquest court so that we move to the scene of the crime and that work starts? Your Honor, that is for the abundance of caution that the court have given you the authority. You will assess whether this matter, and now Mr. Whitty can understand what I'm saying, flagrant disregard to sections of the law that are statutory is political. That is why McClellan is saying. We have no more to add.
Yes, Lord. We will have very brief comments. Unfortunately, was unlucky we will not have the leg room to go political. I'll start with the last point on whether or not an inquest which has been brought through the window is available or is an obligation of this court as suggested. It's something I've written on, so I can quote one decision on this. Understandably, the decision that Mr. Omari has referred to the court to, if I got him right, is a decision of number 96 of 2011, Your Honor? 93 of 2011. So, is my good friend, he may not have seen what Honorable Justice William Musyoka says in Dennis Rosanna Manyibe.
Could you give us the
I will give the citation. We didn't know you raised the...
We don't do this. It's okay. Just give the citation.
Your Honor, Dennis Rosanna Manyibe and 4 others versus ODPP and 2 others. The good judge is not only an authority in law of succession. He delivers a beauty of a judgment. The citation of this case is Kakamega Criminal Revision number E001 of 2022. E001 of 2022. And basically what the judge is doing is the nature of inquests in post-2010 Kenya. And I'll read one paragraph. This is what he says. I quote him, "The first is whether it was necessary," which is what Mr. Omari is telling you, "in the first place to conduct the inquiry in view of the letter by the first respondent, the ODP, the purpose of conduct of inquest proceedings is to primarily determine the cause of death, particularly where it is suspected that the same was by hand. Where the persons responsible for the death are known, there will be no need to conduct an inquiry. The suspects ought to be arrested and arraigned to answer to a charge of either murder or manslaughter or any other related offense. The inquest will be conducted where there is doubt or where the accusation is clouded in some mystery for the court to unravel the mystery. Where there is no mystery or the circumstances are fairly clear, then the first and second respondents need not ask the court to conduct an inquest. Now, this is part of the law on inquest post-2010. There is a similar decision by J.B. Ojwang. He was a judge by the time. He rose all the way to the Supreme Court. And the decision which I would invite the court to have a look at is Nisha Sapra versus Republic. This is way before the Constitution of Kenya 2010, but it still has the same principle. There's also the decision of Honorable D.S. Majanja J. May the Lord God put his soul in eternal peace, in re-estate of Philip Otieno Odhiambo. Re-estate of Philip Otieno Odhiambo. This is reported in 2015. And finally, on the question of inquest, one of my favorite judges, Justice Mwongo, my phone has just gone off, Your Honor, but I'll provide Justice Mwongo's decision.
Help us more knowledge. You know, we are students. In those decisions, where was the scene of the death? Just tell the learned.
All right.
Only that.
Sorry, Your Honor, we will not answer that now. Yes. Thank you very much, Your Honor. I am done with the point. Thank you. Thank you. Thank you, Your Honor. I am well guided. Actually, that's why I started with it first. We are done with the question of the inquest. Now, Your Honor, I wanted to read for you the decision of Titus, the Court of Appeal decision on Titus Act. I think the defense have treated this matter with some lack of seriousness, with a lot of respect. And that's why you hear questions like, release him on a bond of 7,000, release him on free bond. Your Honor, this court is bound by Section 60 of the Evidence Act, and this is 60, subsection 1, subsection O, to take judicial notice of matters of public notoriety. Judicial notice of matters of public notoriety. This court is human and does not live in vacuum. This court has eyes. You can see the number of media officers here. You can see the number of Kenyans in court today. This matter cannot be treated with a lack of seriousness. And what is the matter? The matter is that we are saying a Kenyan died in a Kenyan police station. That Kenyan is identified as Albert Ojwang. So now, of course, we are both laws, but that's not why I'm making this argument. True. That is a disclosure of conflict, possible conflict if there was. There is also admission from the defense that the person sitting as the respondent before you is the OCS. While they had questioned it in their affidavit, they have admitted severally. And not just the OCS. He's the OCS of, according to Mr. Kumekucha, one of the greatest stations in Kenya. And that is not enough. According to Mr. Omari, he has been in the police service for 29 years. Now, with that point of reflection, just before I get to the decision of Titus Ngamao Musila Katitu, a police officer who has been in service for 29 years, who else would have more influence, either on witnesses and or the investigations? And with that point of reflection, allow me to just read paragraph 1, because the Court of Appeal, this is what the Court of Appeal says in the decision of Titus Ngamao Musila Katitu versus Republic. This decision is delivered on 24th April 2020 by Justice William Ouko, may rest in peace, Fatuma Sichale, and sorry, William Ouko, I withdraw that, Fatuma Sichale and Ole Kantai. And this is what they say. This is why it is hurting me at this point. The blue code of silence, which we have been told not to talk about, is a common phenomenon spanning across different countries and police cultures in America, Europe, Asia, and even Africa. Kenya is part of Africa. You're not allowing me to just read this. It is the unwritten rule according to which police officers never provide incriminating information about colleagues, to close ranks in silence, and to cover up knowledge of a fellow officer's wrongdoing with a collective blanket of self-preservation. The offense we are talking about today is the offense of murder. There is no greater offense leading to self-preservation than the offense of murder. We admit that all offenses in Kenya are available, but there is no greater need for self-preservation where a police officer, no less than the officer commanding the station, is intended to be likely charged with the offense of murder. a feeling of esprit de corps among officers who by and large depend on each other for their very risky lives as they confront the violent and hostile world of policing and crime. This background is important, and I hope it is also important to us today in our consideration of this appeal, because the police in Kenya, as we shall demonstrate, the three judges are speaking, as we shall demonstrate in this case, as in others before it, has in certain circumstances engaged in the practice of covering up for each other. And the court proceeds to give examples. So that we are saying, when we say that the respondent before you is likely in the act of self-preservation interfere with ongoing investigations, we are not plucking it from the air. There is basis of it. The Court of Appeal has seen it before. Now let us go back to the, yes, I hope the court will have an opportunity to look at the other parts. Let me go back to the application so that we get back the court to our application, because we may have lost what we are asking. And Mr. Kalai did a good job in referring you to the orders we are seeking. Your Honor, the limited order in prayer number B is that the respondent be remanded at the Langat police station or any other police station within the Republic of Kenya as the investigations may dictate, to enable the applicant conclude investigations. The main primary reason why we are asking to hold him is to enable the applicant, IPOA, complete investigations. John, now, there are very few questions which are necessary contextualized. Is Albert Ojwang dead? Yes. Did he die in a police station? Yes. Was the police station, Central Police Station in Nairobi? Yes. Is the respondent the officer in charge of that station at the material time? Yes. Has the IO informed you that investigations are ongoing? Yes. His affidavit evidence has not been contradicted or controverted. There is no denial that there are investigations. Coupled with the public interest, even as we presume the respondent innocent, would it be in the interest of the victim? We have seen, just like them from social media, the father of Albert Ojwang confused, running across Nairobi. Is it in his interest as the victim and his family that the respondent should be released on 7,000 or freeborn? Because the rights belong to who? Accused person. And our answer is no. Your Honor, we are at an investigation stage. A decision may, most unlikely, but may still be made, that the respondent in the dock is not to be charged. The decision to charge him or not has not been made. We are asking you, because of the complexity of the matter, and because of the blue code of the police, which has been judicially noticed by the Court of Appeal of this country, allow us 21 days to complete investigations. If the investigations are complete before the 21 days, Mr. Jibril is a good man, except that he gets a little angered like me sometimes. If we complete these investigations before the 21 days, Mr. Jibril, you can confirm we can come back to court.
Yes, Your Honor, I do confirm.
We pray with you that approximation as per now is that 21 days will do justice, not just to us, but also the respondent, so that we establish, as his advocates are suggesting, that he was not involved in this matter. As I conclude, Your Honor, there is a deliberate distinction by prioritization of Article 49(1)G and Article 49(1)H. I have always believed that when provisions of the law are put distinctly and separately, they mean different things. So that on the burden and standard of proof, Article 49(1)G, which requires at first appearance that he be charged or informed of the reason for his detention or to be released, once we have given the reason, we have met the threshold. And that the arguments have been made, and that explains why most of the decisions that have been presented to you are decisions on bail pending trial. So that all we needed, in my view, in my very respectful view, is that the threshold is met once the reason is given and it is satisfactory to the court. The arguments about compelling reasons, arguable reasons, are reasons which are better still placed on arguments of bond pending trial. Let me hit the last point, which is apprehension vis-a-vis likelihood. I have had Mr. Mpeta, who I respect so much because the decision in West Agarai is one of my best read decisions in this country, tell this court to ignore the bail and bond policy guidelines. Although he said it in passing, but that was very unfortunate in my view. Because the bail and bond policy guidelines is intended to standardize the application of the law on bail and bond in Kenya. And if I get it right, I think it is clause 4.9 of the bail and bond policy guidelines. The word likelihood is used at least 3 times, so that the likelihood to interfere with investigations is a sufficient ground, even if you are pending trial, to deny bail. But on this lower threshold of abundance of probability, where we are asking you to let us complete investigations, the likelihood to interfere with investigations, as my brother will tell you, where there has been uncontroverted evidence of interference with CCTV, that likelihood is very high. And because of the blue code, please hold the respondent for at least 21 days. I submit and I am ready. Thank you very much.
Yes, Your Honor, just to finish,